I am Dr. Bahaudin Mujtaba, and today I have my colleague and mentor, Dr. Frank Cavico here, who is the lead author of business law textbook, as well as the legal challenges for entrepreneurs and managers, which is being used in most graduate programs throughout the United States and abroad. So today we're going to talk a little bit about the legal challenges that human resource professionals and managers, both in the public sector and government sector, as well as in private sector, need to be aware of. So I will ask him some questions so he can share some of his insights. Now, Dr. Cavico has been a professor for over 30 years here at Nova Southeastern University in South Florida, as well as obviously an expert in the area of law. So he can tell you a little bit more about his degrees and certifications and background. In the meantime, I should mention that now he is a professor emeritus status at Nova Southeastern University. So he teaches regularly. And now turning to you, Dr. Cavico, first of all, thank you for giving us a little bit of time to share your insights with all of our audience, students and managers throughout the United States and abroad who get to see the lecture. First of all, would you be kind enough to share your insights about your background and the reasons or the purpose why you chose to specialize in the area of law and get your Juris Doctorate degree in obviously in the area of business law, as well as in the area of ethics and morality?
Thank you. First, let me say it's absolutely my pleasure to be here. I enjoy this very much. I like teaching people about the law, and in particular how to avoid legal problems. As I said, my background is predominantly a law. I went to a law school at St. Mary's University in San Antonio, Texas, for my JD, and I also have an LLM, which is a Master's of Law in torts and products liability. I've done a lot more with employment torts than products liability through the years. I also have a undergraduate degree in political science and a master's degree in political science at the Huizinga College of Business at Nova Southeastern. For many years I've been teaching our undergraduate business law courses and also our graduate level course, which is more of a government regulation of business and ethics course. Although actually in both courses we've incorporated ethics as well as social responsibility and sustainability. As I said, I've been an educator for many years. Before that, I was a practicing attorney down in Miami. I enjoyed that, but I'm hesitating a bit. But what I didn't enjoy was people being taken advantage of, in particular being taken advantage of, particularly in a business sense, by the moral gaps in the law. In other words, the law strives to be just, but the law is not equivalent to justice. And there are moral gaps in the law. By that I mean that it's very possible for someone with superior knowledge of the law to take advantage of someone who lacks that knowledge. An example is an actual case dealt with someone lying to another person, but lying about the law, as was the applicability of a zoning ordinance. Zoning ordinances are law. And, you know, a lying, if it meets certain requirements, can rise to the level of fraud or deceit, which is a legal wrong, and certainly a vehicle to set aside a contract. But there's a major exception, and that is lying about the law, a misrepresentation of the law. That's not a legal wrong as a general rule. Of course, with the law, there's always rules and exceptions to rules. But that, as a general rule, is not fraud, because everyone is presumed to know the law, because ignorance of the law is known as excused. So if the law presumes that you know the law, how can I lie to you about the law? Because you know the truth. If you follow the, I don't want to say twisted logic, but the logic that can lead to very unjust results. And I also remember from law school days, a famous quote by Lord Mansfield from back to the 1700s, and that the purpose of the common law is to protect the weak from the abuse and insults of the strong. So throughout my career of practicing law, and for my many years, as you mentioned, as a professor at Nova Southeastern and other schools I've been affiliated with, I've tried to focus on preventative law. In other words, making the students as well as the business community do seminars and lectures, making people aware of the law and the moral gaps of the law. I want to make sure they know their rights, but they also know their responsibilities under the law. And that's been the thrust of my dealings here at Nova Southeastern for many years, and even before that. To be forewarned is to be forearmed. So you know the law, particularly those gaps in the law in which what immoral but legal conduct can occur. That is very important. And one example, if you're an employee at will, you can be discharged for any reason, no good reason, even a morally bad reason, such as nepotism, or even to make it more salacious, even a paramour preference. Discharging someone to make a position for whom? Your girlfriend or boyfriend. Which, I might add, is very dangerous with the body of sexual harassment law, because a lot of times these relationships at work can degenerate into very nasty sexual harassment lawsuits. But you have to remember, if you're an employee at will, you better start saving some money, because if the plant is closed and it's shipped overseas, you're out of a job. Amazon is moving headquarters from Seattle to New York and Northern Virginia as we speak. Hopefully there'll be some transfer options and severance packages, but you're an employee at will. You're in a very legally exposed position. You're a Bernie Sanders supporter and I'm a Trump supporter, and you come with your Bernie Sanders t-shirt and I fire you. Well, you're an employee at will. Title VII is not going to help you. But because it's a federal system, as I emphasized, there may be some states or local communities that will protect you in employment because of your political beliefs. So, as I said, I can go through lots and lots of examples. I'll stay out of politics. You come in with your Green Bay Packers t-shirt, and you work for a Dallas company. This is an actual case, and it's Dallas, and it's the weekend of the championship game, and I fire you, not because of your race, your color, your religion, but I fire you because you're a stinking Green Bay Packers fan. You're a traitor to Dallas and the Cowboys. That's legal. Whether it's moral is another issue. Whether it's even smart, as a good employee, that's a whole other issue too. But I'm saying, know your rights, but also know your responsibilities and what can happen to you. And one more example. A covenant not to compete, employee signs a covenant not to compete in the vast majority of states. And the employer, the covenant is reasonable as to time, is reasonable as to area, and the employer has a justification for the covenant that's legitimate, protecting a goodwill, a customer list, something, a trade secret, something of that nature. Well, you're discharged, an employee, well, through no fault of your own, economic downsizing, and because you signed this covenant not to compete, you're precluded from taking, of course, one short period of time, 6 months or a year, you're precluded from taking a job with a competitor in the trade territory. But I won't be able to pay my rent, I won't be able to feed my kids. The judges there, we don't like the law. Those three requirements are met. As I said, you're discharged, and there's not much you can do about it legally. So, as I said, not to belabor the point, know your rights, know your responsibilities under the law. That's been my emphasis of my many years teaching.
So there's a lesson there for all of our managers and students to be very careful what you sign.
That's right.
Covenant not to compete.
Well, that's right. Look, of course, people at your level, that's one of the reasons why you're here, listening to our talk here, why you're going to school, attending seminars, is, as I said, to make yourself educated in this regard, but also to make yourself more marketable. So if that does happen to you, the plant moves and you lose your job and you can't take the transfer option, you're still a very marketable employee to another firm, although you may have to wait 6 months or leave that trade territory. But also, Dr. Mujtaba said, sign the contract. Maybe at your level, you can negotiate the parameters of the contract. I wouldn't go there in the attitude, you're a big pen, and let me X out this covenant. And what's your prospective employer saying, next candidate, please. But, maybe in return for the promotion, you sign the covenant if it has a short period of time, or maybe if the covenant is the whole United States, maybe you can point out to the employer very diplomatically, look, you don't have any business in the Pacific Northwest, and you don't have any plans to go there, can we exclude that part of the territory from the covenant? So, people at your level, one of the reasons why you're here is to gain that level of marketability and get a little, you're not going to be the dominant economic power, but to gain a little power in negotiations with your employer, at least to see if you can modify some of the parameters of the covenant. Or you're willing to sign the covenant not to compete, short period of time, a reasonable trade territory, but also if you get a severance package. You want 6 months covenant, I'll sign it. I'm looking forward to my promotion, my new position, higher salary, but I want a severance package and continuation of health care for the 6 months. That seems very, very reasonable to me. So I said, know your rights, know your responsibilities, and as I said, educate yourself and become more a powerful entity when it comes to negotiating with employers.
So as you can see here, Dr. Frank Cavico has a lot of experience, brings in a lot of cases from around the United States, around the world, to share with us, and not only here during this interview, but obviously in his writings and textbooks, some of which are very, very scholarly. So that's why obviously we're here. So you can briefly tell our audience, what is employment at will in the United States? Because I don't know to what extent it applies abroad, but in the US, as long as you're an employee or a manager, you should be aware of employment at will. So does that apply to all the states within the United States, or is it limited?
Just about. And you said United States versus internationally. U.S. is very unique in employment at will. It's a very legally exposed position for an employee to be in, and most employees in the private sector are employees at will. Employment at will means that you either do not have an employment contract, or if you have a contract, the contract doesn't specify the circumstances under which you can be discharged. If that is the case, there's no limitations on the employer's ability to discharge you in a contract. You are an employee at will. A lot of employers will say in their codes and manuals, say, congratulations for joining our firm. Oh, by the way, you are an employee at will. And that means you can be discharged anytime, any reason, no good reason, and even the old cases say even for a morally bad reason, like nepotism. The wife says, you got to fire someone to make room for the niece. She needs a job, and you're there, but fire whom? These are all good employees. They help build my firm. And he said, no. You got to fire someone. The niece needs a job, so I have to discharge someone who's been an exemplary employee, help make my firm successful, to put in the niece, so hopefully can do the work. Well, that's not right. That's not fair. That's not moral. That may be true, but it is legal. However, an employee at will cannot be discharged for an illegal reason. That will make the discharge a wrongful discharge. And when you hear the term wrongful discharge, you're thinking in terms of illegal discharge. With employment at will, you can have a discharge that is immoral but legal, and that's the risk of it. And all states in the U.S., I believe maybe one or two, and I believe Puerto Rico, have some limitations in which an employer has to set forth a reason for the discharge, and has to be a just reason, or reasonable reason, or a legitimate reason, depending on the state's verbiage. But the a vast majority of states have employees as employee at will. Of course, an employer can change this. In a contract, an employer may say you're entitled to a hearing and an appeal of that hearing, but most employers like the flexibility of having their employees at will. So you got to move the plant, you got to move the plant. You may have to give this to the Warren Act, you may have to give a notice to the mayor that Amazon is leaving Seattle for New York and Northern Virginia, and then you make the move, and employees who can't make the move or whatever, those are terminated employees, hopefully with the severance packages. Internationally, students here, for example, Thailand have had students, and from Latin American countries, they're shocked. They're absolutely shocked. From France and Europe, they're shocked that an employer can just fire someone and there's no severance. And they say, you want severance, go to Sweden. Unless, once again, you can negotiate severance in your contract. And as they say, one of the reasons why you're here getting an education is to make yourself more attractive as a candidate for employment, and maybe you can negotiate some severance. But I say, you want paid family leave for the mother and the father, go to Sweden, and maybe be prepared to pay some significant taxes for that, but not here. So as I said, it's a very legally exposed position to be in. And so if you're an employee at will, you're looking for some legal theory, whether by statute. So you're discharged because of your race or your color or your gender. Or you're discharged, that's obviously what triggers the Civil Rights Act, Title VII. Or you're discharged because you came to work with a union button on. Oh, it's a stinking union member. I don't want a union. It's here, so I fire the employee. Well, that's an unfair labor practice. That's a Section 8 of the National Labor Relations Act. You've got a case now. And so you have to go through. Some states have whistleblowing statutes. Why you're being fired? Because you blew the whistle. You disclosed to an appropriate government agency, not the media, or the media later, but you first disclosed the legal wrongdoing of your employer. That's if your state has a whistleblower protection statute, or if your company is publicly traded, regulated by the SEC, and you're disclosing to the SEC some type of securities fraud or embezzlement that would impact the shareholders. You're protected then. So you're looking for something statutory to protect you, or something common law, judge-made theories. Maybe you were discharged, but incompetently so. That's a tort of negligence. Or maybe the reason you were discharged is because the employer found out that maybe you were dating a coworker in violation of the employer's policy, which is good grounds for a discharge. Debate that issue. But how did they find out about that? They were snooping around your home, using those with Zoom cameras to check out your bedroom. Well, guess what? That's the intentional tort of invasion of privacy. Or you're an employee, you're being fired in such a demeaning and disrespectful manager, accusations of theft, get the employees together, they make a spectacle out of you. Here's a plastic bag, put your belongings in there, never come back here again. These are actual cases, never come back here again, you thief, whatever. First of all, the person's not a thief, that's a lawsuit for defamation. And then you make a spectacle, you're laughing at a fired coworker, you're mocking them. That's the tort of intentional infliction of emotional distress. So if you're an employee at will, you're desperately looking for something, statutory or common law, to combat the discharge. And if you can't, if I have a final legal theory, or if you don't have the evidence to support it, what can I say? Life is tough. You are a discharged employee at will, and if you sign the covenant not to compete, you may be restricted, at least locally, for future employment opportunities for 6 months or a year. So, as always, know your rights, know your responsibility. And as I said, the doctrine of employment at will originated in England. But one of the students told me it's not even the law of England anymore. And maybe some of the Caribbean, English Caribbean countries it is. Next time the Cayman Islands, we can check it out. But it's certainly the law here. Here's how it's defended. It's a symmetrical and balanced doctrine. The employer can fire the employee at will anytime, any reason, but guess what? You're the employee. You can quit anytime or any reason. What's the old country song? Take this job and shove it. Of course, in the present-day economy, who has greater bargaining power, negotiating, who's the dominant economic power? It's the employer. And most employers are not running around saying, take this job and shove it. But that's how the doctrine is defended.
No, in terms of employment at will law, does it apply the same way in private firms versus government or public sector?
No, most government employees are protected by civil service. And then remember, government employees have constitutional rights that they can assert against their government employer. For example, if a government employee wrote a letter critical of the mayor in the local paper. Now, you may win, you may lose. That's a whole big body of law, First Amendment rights of public sector employees. But they're covered by civil service. And a lot of times they're unionized by public sector unions, which means what? That certainly government can fire an employee, but there's going to be a hearing, and maybe a union rep at that hearing, and an attorney provided by the union, and an appeal process. What do you get in the private sector? You're an employee at will, there's the door. Here's your stuff. And actually happened to someone I know. I said, give us the keys to your company car. Give us your phone. He said, well, can I call my wife to pick me up? I said, well, security escort him out here. Let him make a phone call to the wife. That's what can happen to you, but not in the government service. However, no, the higher you aspire to and achieve in government service, you may lose your civil service status and become an employee at will. Now, I forget the exact levels of the federal government. I think if you become a level 14 in their government service, you become an employee at will. And the idea is the president is elected, the president appoints heads to the agencies, and the heads of the agencies, they appoint top-level people in the agencies. Those top-level people serve at the will of the head of the agency, and he or she serves at the will of the president. And that's obviously the president of one political party, political philosophy. You want to make sure that the heads of the agencies and the top people of the agencies making policy are in accord with the president's political philosophy. But everyone, I believe, 13, down to 7, however the federal system goes, those people would be protected by civil service.
Well, so it's good for everybody, obviously, to keep in mind all of this information, whether they're in public sector or private sector, that people have the right to obviously be treated fairly, but obviously you have the right to quit your job at any time you want to, and the manager has the authority to fire you at any time he or she wants to, for good reasons, bad reasons, or no reasons whatsoever. When I was a corporate trainer, we used to have workshops with managers, and the workshops would be 3 days. The first 4 hours when the managers came, we said, you are the manager now. You have a lot of power. If you don't like an employee, if he or she is not doing a good job, you have the power to fire that person for any reason, no reason, or obviously good reasons or bad reasons. And then we spent 2.5 days telling them why they cannot just fire anybody at any time because, again, of legal consequences based on gender, based on race, based on ethnicity, and obviously the other laws that apply here. So as you've suggested, obviously everybody has to get educated, become aware of the laws, and obviously behave appropriately to be legally compliant, and also to just be a good manager. And obviously if you do happen to fire somebody because an employee disappoints you, he or she has been a good employee 2 to 3 years working with you, you trusted this person, you have the person get promoted, but the person steals or does something that is totally immature or inappropriate or very unprofessional, be very careful how you fire or terminate the person. So just because somebody made a mistake, an employee, does not mean that as a manager you have to say something inappropriate or unprofessional. Fire the person, but fire the person professionally based on laws. Otherwise, as you alluded to, it can get you in trouble again because of defamation or other consequences.
Make sure you have a legitimate reason.
Right.
And if it's a truthful, legitimate reason, that's a truth is an absolute defense. As you mentioned, defamation to defamation. But be careful. Although a lot of employers are very sort of reticent about writing letters of recommendation because they're very worried about defamation law. So they'll say the employee worked for us from this period of time to this period of time, and that's all. There are some qualified privileges, but most employers shy away from recommendations because of defamation law. So, as I said, it's not just the law, defamation law, the civil rights law. You want to handle people in a careful manner, but it's also a basic respect. You want to develop that corporate culture that you're not acting in an arbitrary, capricious manner. You don't abuse your discretion. You act within the confines of the law as well as morality and treating people with respect. And as you said, if someone commits an egregious wrong, to theft, something like that, or steal trade secrets, then obviously you have very good grounds to discharge them. Let's say make sure you're discharging people in a legal and in a moral manner, in a respectful manner. And sometimes, as I said, there may be economic rationales. You're closing a plant and moving it overseas. And then we want to try to mitigate some of the adverse consequences of that, severance package, help them write their resume, help them find a new job. And I think that's basic fairness and that's basic respect. And as I said, you act legally and morally, and then also socially responsible manner. You contribute to the community. You get involved in a prudent manner, and you're environmentally conscious, and you have that reputation. You as a manager and your organization as a whole of being a legal, a moral, a social responsible, and an environment responsible individual and organization. As I said, even though this takes some time and effort to do and do properly, you will benefit and your organization will benefit along, and so will your family, your community, and society as a whole. So anyway, I guess basically through the years teaching business, that's what I've been selling. Act legally, act morally, be socially responsible, be environmentally responsible. The phrase sustainability is used. And if you do all that and take a long-term perspective, we will only take a little short-term sacrifice. As I said, you will have true sustainability. The profitability and sustain for yourself, your organization, and I said all the stakeholders, your organization, and you and your family will benefit, and society as a whole will benefit.
Right. Excellent point in terms of the pillars of sustainable organizations. And obviously, as managers, if we don't do a good job, we're not going to be sustainable in those professions because, again, employment at will, our organizations, our customers, our bosses can say, okay, you're gone. Now, speaking of...
And employees can say they're gone too.
Exactly.
And so, a lot of good employees leave. And if someone said that I never really got fired, I left these jobs because I didn't like the corporate culture. I didn't like the way, not even me, but maybe other people were being treated. So you want that reputation of legality and morality. As I said, not just for your employees, which is critical, but also for your customers and clients and the greater community, the legal community, the political community, say this is a good firm to work for. They know what they're doing. They make good decisions from a business standpoint, good profitable decisions, but they always act in a legal and moral manner, and they give back a bit. No, I'm saying a bit. I'm not saying bankrupt the company, give everything away, but give back a bit to the community. And then also be environmentally conscious, trying to save as much water and energy as you reasonably can under the circumstances.
Yeah, about a year ago, I had a chance here to meet with Ben and Jerry's founder or co-founder, Jerry, who was here at South Florida. And he mentioned that they actually measure two bottom lines. One is obviously profit, but the second part of it is basically how much good did we do last year to the communities where we work? Did we help employees? Did we help employees' families? Did we help the communities of our customers, our vendors, and so on? So I thought that was a very important point. Earlier, you brought up the idea of defamation, that unfortunately sometimes managers say the wrong thing to their employees. So if my boss, who is, let's say, a top-level manager in the organization, let's say where I work, and he or she says, "Oh, Bahaudin, you're stupid, you're dumb," and he or she prints that on social media, Bahaudin was a dumb manager, we never wanted him in this organization. Now, what are some consequences of that in terms of defamation or slander? Any thoughts you can share with our audience?
Right. Well, in essence, defamation consists of false statements of fact, not opinion. And I actually remember cases of upper level manager accused of somebody being unethical. Well, it sounds defamatory to me, but the court said no, that was an opinion, as opposed to, you stole confidential information, you stole trade secrets. But maligning someone's a character would be grounds for a defamation, as well as harming them in their business or professional relations, and they're going dumb or stupid as a manager. That certainly would be harmful. But you always have to weigh the law. There's lots of twists and turns to law. You have to go, that's just my opinion. You're not a good manager, you're a stupid manager, you're a dumb manager. That's my opinion. Defamation, you need false statements of fact. You're a bad manager because of this bad decision that you made, which, as I said, better be true as far as the person making a statement, because truth is an absolute defense. But also there has to be publication. In other words, if it's just a manager and employee, and the manager makes a statement that maligns the employee's character, and no one hears it, that's not defamation. That's not defamation. If it's so severe, of course, you need witnesses that maybe it's intentional infliction of emotional stress, but that's very tough for a lawsuit to make out. So there has to be some type of publication. I mean, just even if one other person hears it, or put on the company bulletin board, either a ground bulletin board or a virtual bulletin board, or email is sent, but you need that level of publication. And that's where a lot of companies look on an employee at will. They don't have to give a reason for your discharge. You're fired. By thinking you're a dumb manager, whatever, or I think you're a thief, but I'm not going to say anything. I don't have to give a reason. And I'm certainly not going to give my reasons in a letter of recommendation, because I'm worried about the definition. But you need that statements of fact and not opinion. And that's a very interesting area of the law, more for a law school level, because people give opinions, and an opinion is not fact. However, opinion is not based on just sheer conjecture. Usually there are some facts underlining, supporting an opinion. And so the question is, how many facts do you need behind an opinion to turn the opinion into a fact? So not the time of her, but that's how lawsuits develop. So as I said, look, if you really want to give a reason when you're firing someone, and the reason maligns their character, their competence, may hurt them professionally in their business, just make sure that you're right, and that the opinion, and that the accusation is a correct one, and that it's as I said, if it's of a factual nature like that.
Okay, well, thank you very much. So the lesson here is obviously be careful of what you say, be careful of what you write, be careful of what you post on social media about other people, other individuals, and so on.
That's right. And as we're still saying, be good, but if you can't be good, be careful.
Dr. Cavico, thank you very much for sharing your insight in the practical examples and the case studies, some of which have obviously gone all the way to the Supreme Court level, where decisions have been made for employers, for managers, for even individual professionals and employees to treat each other and obviously their colleagues and their bosses, their customers, and their employees in a respectful and dignified manner. I should let everybody know that Dr. Cavico is the lead author of this textbook entitled Business Law for the Entrepreneur and Manager. Now it's in its third edition, so.
Excuse me if you're going to point out the co-author.
Yeah, of course, I did a little bit, obviously. I've learned a lot because Dr. Cavico is one of my mentors, has been one of my mentors for the past almost going into the third decade here. So this is a good textbook. Majority of the material that we discussed, the legal theories and concepts are comprehensively discussed, obviously, in the textbook. And also, Dr. Cavico is the lead author of this other textbook, which is used in most graduate programs, entitled Legal Challenges for a Global Manager and Entrepreneur, published by Kindle Hunt Publishers. So again, this is also available through the publishers. So a lot of good material out there to help managers, human resource professionals make good decisions that are respectful to all employees and their customers.
Thank you, Dr. Mujtaba. It's been a pleasure. And I'll point out that both pictures on those books are Venice. And I remember Venice was a very, very successful city-state for many years. And hopefully everyone will have a chance to travel there. Don't go now because it's underwater, Seymour Square. But the motto of Venice was, as I said, a very profitable international city. Their motto was for the honor and profit of Venice. And, you know, we're in a college of business here, and we want you to be profitable. And we're here to teach you subject matters and impart knowledge, give you skills for you to be and your businesses to be profitable. But we want you to be profitable in an honorable way, for the honor and profit of Venice. And that means acting always in a legal and in a moral manner, for the honor and profit of Venice. So we can emphasize both those concepts.
Well, thank you very much.
Thank you. It's been my pleasure. Thank you all.